Hello, I'm Ronnie Eldridge. Welcome to Eldridge & Company. The decisions of the United States Supreme Court have always affected the lives of all Americans. But even now, while the current Supreme Court reshapes our politics and redefines civil liberties, the justices and how they work is a mystery to many of us. I've invited Kate Shaw, professor of law at Benjamin Cardozo School of Law, whose teaching and research include constitutional law and the Supreme Court, to be my guest today. So welcome.
Thank you for having me.
Thank you. This is an interesting court because there's so many cases that we're reading about as they pull them up and we hear about it. And you worked in the court. You were a clerk in the court.
So I was a law clerk to Justice Stevens in 2007, 2008. So it was 2 years into the sort of term of the Roberts Court. So still the early Roberts Court era. But yes, I did clerk for this Supreme Court.
And Sandra Day O'Connor was still there?
She was gone.
Oh,
Justice
she was
O'Connor
gone.
was gone.
Was
you know,
that
she
her
was,
first year gone?
It was her second year gone, but she was still very much a presence actually in the building. So I actually did get to spend quite a bit of time with her, and she's a wonderful person, but she was no longer an active justice.
Are they all wonderful people?
I have my preferences.
None
is as wonderful as Justice Stevens, I would say.
Well, you were lucky, really. You had the prize.
I was extraordinarily lucky. But there's not a ton of opportunity for sort of social interaction with the other justices that the law clerks have. But at one point during the term, ordinarily, each of the group of clerks takes each of the justices out to lunch. So I had occasion to have lunch once with each of the justices while I was there for a year. And they're remarkably charming and obviously all very, very brilliant people. So, you know, we had a wonderful lunch with Justice Thomas, who's an incredibly warm and lovely person. So, personally, I came away with very warm impressions of all of them.
Why doesn't he talk during the proceedings?
You know, he has said that he believes his colleagues speak too much. They speak to hear themselves speak as opposed to sort of learn about the cases or to educate the public. So I think he thinks there's a sort of a performance aspect to the questioning that he doesn't entirely endorse. Now, I think there's a degree of truth to that, but they also sort of use the questions to probe weaknesses or to probe the outer limits of the parties' cases. There's also, I think, an important sort of public education function that sort of to demonstrate the justice's engagement with the issues. I think it's a very sort of pure exchange of ideas, actually, that occurs during oral argument, and I'm glad that most of the justices engage in it. And Justice Thomas engages very deeply with the cases. There's no question about that. And I think it maybe creates a misimpression that he doesn't because he doesn't ask questions. Yeah. So I wish he would occasionally.
How do you become a clerk to a justice?
Ordinarily, you clerk for a lower court judge first. So frequently on the Court of Appeals, not always, but that's usually the sort of path. So finish law school, clerk for a Court of Appeals judge, and then
you have to be a good student.
You have to be a good student. It's sort of a strange skill set to perform well in law school exams and in law school. But if you sort of have those threshold qualifications and you have a clerkship for a Court of Appeals judge, then you send in your applications and hope for the best. And most of the time, the sort of candidates will apply to all of the justices, and I did that.
What makes a good law student?
Mostly you sort of need to be willing to work harder than anybody else. So I think that's a lot of it, is just sort of putting in the hours. But law schools, there's ordinarily just one exam at the end of the semester, and so your performance rises or falls on your sort of the 3 hours that an exam occurs during.
Do you think you have to think a certain way? I mean, is there an instinctive quality that makes a good student and lawyer?
I mean, critical thinking, the ability to sort of make effective arguments and counter arguments. But I don't know that there's a particular background. I mean, I think I had colleagues who were very successful law students who had engineering backgrounds or who had literature backgrounds. So I think an active and curious mind and an ability, I think, just to engage in different modes of argumentation is really all that's kind of essential. I think there are lots of different ways to be a successful law student sort of within that framework.
So I'm sure that the law school supported your application, right?
They did, and actually Justice Stevens is a graduate of Northwestern, which is where I went to law school, and so he didn't always, but he frequently would take one law clerk from Northwestern. So and I'm from Chicago, and he's from Chicago. So there was a lot of luck and chance involved in the reasons that I think I was selected. And yes, the law school, my professors were very helpful.
So they must get thousands of applications. They narrow them down.
Right.
And then you have an interview?
Yeah, so they narrow them down, and then you come in for an interview. I mean, once upon a time, it was a very informal process. The justices would just sort of call up a trusted colleague on a law school faculty and say, who should I hire this year? So Justice Stevens, for example, he clerked on the Supreme Court when he was a new law school graduate in 1947. And there was no interview. There was just, it was he and there were two co-editors-in-chief of the Law Review in 1947. And so the two of them sort of were told by the faculty of Northwestern there would be 2 clerkship spots available, one for the Chief Justice and then one for Justice Wiley Rutledge, for whom Justice Stevens ended up clerking. And he and his co-editor-in-chief flipped a coin to decide who would get which of the clerkships, because one started a year earlier than the other. I'm sorry, no, one was a 2-year clerkship and one was just one. So that's how it happened once upon a time. Now it's a pretty competitive selection
So you
process.
get selected. Then do you go to school again about how it works? What happens?
Less than you might think. You sort of get thrown into it pretty quickly.
And when do you start working? Because the term starts after the summer.
Exactly. So the term starts the first Monday of October. The court sort of hears the first cases argued. It actually starts in late September. The justices kind of return from their summer travels and begin reviewing the cases that have accrued over the summer. But the clerks begin sort of in a staggered fashion over the course of the summer. So usually 1 in June, 1 in July, 1 or 2 in August. Usually there are 4 clerks per chambers. So you come in during the summer when the cert petitions, so the petitions vying for review by the court, sort of requesting to be heard by the court. Many of them have come in the spring, and then some of them continue to come in over the summer. So you're just reviewing cert petitions, but the cases, there's no active cases being argued until the fall. So it's actually kind of a good introduction in that you have the volume of cert petitions is quite high, but you aren't also trying to balance oral arguments and drafting or assisting the justices in drafting opinions. And also you get a little bit used to sort of being in the court, sort of the majesty of the surroundings and sort of the magnitude of the work without the justices being around. And in a way that's good, because you can get you can get your bearings and get comfortable, because, I mean, Justice Stevens is wonderful. They're all, I think, lovely to work for, but they're intimidating initially, right? These are Supreme Court justices, and you are a recent law school graduate. So to get a sense of your sort of surroundings and get your bearings for a couple of months first, I think, is wise. And there's a chamber's manual. Each of the justices has sort of a manual that generally contains the crude wisdom of all the law clerks who have come before you, but there's not as much training as you might expect. You sort of have to begin on day one, start reading petitions, start writing memos.
So do the certs, you call them cert petitions?
Cert petitions, right.
Do they end at the end of the session and now it's a whole new batch, or can you carry over from the year before? If they weren't selected.
If they're not selected, then cert is denied and they're out. Yeah. So,
can they reapply?
Not out of the same case. No. They can seek. Sort of to qualify that a little bit, there's a possibility to seek rehearing or reconsideration those requests are very infrequently granted. There's a possibility sometimes what will happen is a petition doesn't get granted and it also doesn't get denied. It just gets held because another case that might affect that case has been granted. And so frequently a case will be decided, and dozens or maybe even hundreds of other cases that present a similar issue will be in sort of a holding pattern. And so after the sort of case A gets decided, all of the other cases being held will get sent back frequently to the lower courts, for the lower courts to sort of reconsider them in light of what the Supreme Court has said in the interim. So it's not just sort of a straight up or down necessarily with each petition.
So is it basically the clerk's discretion that a cert proceeds on to the next step?
No, I mean, the justices absolutely make the final decision, but the clerks do have a really important role in sort of doing the first review of the cert petitions. And it's just a volume imperative, I think, in that the cert petitions, when I was clerking, it was approaching close to 10,000 petitions a year. I think it's down maybe a little bit now, but around 9,000, something like that. And there are 9 justices, right? There are 36, I guess 37, because the chief has 5 law clerks. And so the way it worked when I was a clerk was that all the justices, except for Justice Stevens, participated in what's called the Cert Pool. So they pooled their clerks, and the clerks just divided among them all of the cert petitions that came in. So each clerk read each petition, I should say, was read initially by one law clerk. The law clerk wrote a memo to the full conference, so all of the participating justices, making a recommendation, grant, deny, and occasionally there were some other hold and a few other options that you could, other recommendations you might make.
But you did your own.
So the Stevens operation was a little bit different. So Justice Stevens wanted to make sure that his law clerks took a look at every petition. So we had a much higher volume of petitions to review. But on the flip side, we also had fewer memos to write because we did not need to write a memo about every petition if we didn't think it sort of rose to the level of the justice needing to pay attention to it. So that meant you had, because we were outside of the pool, you had 2 law clerks taking an initial review of each petition. And frequently they saw different issues, or sort of, and I should say most of the time the recommendation was the same, but not always. And so I think it was a useful check on the cert pool to have sort of some independent operation taking its own look at the cert petitions. But that said, the justices read the memos, and if they have a question, if they want to know more, this happens sort of, some justices do this more than others, but they would frequently ask to see the petitions themselves. So it wasn't at all the case that they were in any way sort of these passive players in the cert review process. And the law clerks in other chambers would also take a look at the memo written by whoever was assigned a particular petition, and frequently would annotate the memo for their justices. So they take a look at the petition themselves, sort of if something struck them as not quite right, or they had a feeling their justice might see a case differently, they would sort of read the underlying materials and then sort of write a cover memo to their justices.
What time did you go home at the end of the day?
I usually did go home. There were a couple of exceptions, but they were very, very late nights, and we couldn't really take any work home, so we you know, 10, 11, midnight. They were late nights.
So does a justice ever look for a certain for an opportunity to hear a specific case?
I think they all are. There are issues that they're all interested in that they sort of realize are being discussed and debated in the courts of appeals, and so they, I think, keep their eyes out. I don't think those usually come as explicit directives to the law clerks, but I think your job, in part, as a law clerk, is to have a very good sense of your justice's interests, and if you think there's an issue that might rise the level of potentially the court taking a case, you know, you could always approach the justice and sort of ask, is this a case, should we be looking out for cases like this? And you can just have sort of a frank conversation about it. But I think they all sort of do keep their eyes out for particular issues in the law they think are unsettled that they might appropriately weigh in on.
And then is the next step the oral arguments?
So right. Well, actually,
once you've picked the cases.
Yeah. So first the briefs get filed. So once the cases are chosen, the parties file briefs in the court, and then once all of the briefing is done, and that's both the parties file briefs and then lots of outside parties frequently, particularly if it's a sort of high public interest kind of case. Many outside groups will file what are called amicus briefs, providing a perspective that's a little bit different from what the parties have provided, and those are frequently very useful. And after all of that, all of those papers are filed, you've had a chance to read all the papers, and then the oral arguments happen.
So, and then after the oral arguments, what do you do as a clerk?
So
you sit in. You're sitting in the audience.
Yes, so a little separate part of the audience. Yeah, the law clerks have their own sort of part on the side of the courtroom.
I seem to remember a trip during my college years where we were there during an oral argument and somebody was slouching. Am I making this up? And one of the attendants or guards.
Oh yeah,
they do. They tell you to sit up.
Decorum norms very strictly. So no slouching, no dozing. Loud coughing is sort of frowned upon.
So all of this is to add to the mystique of the court,
something
right?
like that. Yeah, they sort of do take decorum.
Yeah.
They take decorum very seriously.
Okay.
So yeah, so you're not misremembering. That's
right.
and that's still the case. So right, so the law clerks sit with good posture at the side of the courtroom and watch the proceedings, and then. It depends on sort of the day of the week, but either that day or a couple of days later, the justices have their private conference to cast their votes on a case and to sort of attempt to persuade their colleagues. So that's...
That quickly?
It's very quick, yeah. So it's the same week that the case is argued. So that is a conference in which the clerks do not participate. That is just the justices. And coming out of that conference, the opinion writing has been assigned. So the Chief Justice, if he is in the majority, will assign the opinion. He will keep it for himself, or he will assign it to another justice in the majority. And if he's not in the majority, then the most senior justice in the majority will make the assignment.
They don't really have that much time to really think about this.
Well, they've had a lot of time to review the briefs before before the oral argument. I mean, not a ton of time, but there is some time. So they've read all the briefs carefully.
They can decide what they want to find out.
Exactly. So what do we want to probe? What do we want to ask about during the oral arguments? And are there areas we want our clerks to sort of further research? All of that. So there is time, and you've discussed the cases usually. Sometimes just once, sometimes more than once with your justice before the oral argument. Some justices require what are called bench memos. So basically a short memo from the law clerk laying out the major issues in the case and making a recommendation as to a vote. We actually did all of that pretty much just verbally with Justice Stevens. So there's been some time, but you're right that it's fast after, and in a way it's good because it's very fresh, right? Yeah. So they've read, they've really immersed themselves in the material, they've heard the oral arguments, they've listened to the answers that the advocates gave them and gave to their colleagues, they've had a chance to hear where their colleagues are because of course in the oral arguments they're listening to the lawyers, but they're also listening to their colleagues and sometimes attempting to sort of persuade their colleagues with the lawyer as the intermediary. And then they cast their votes and the opinion writing begins.
So do you think the process are there things that could be done to make it more open and more accessible to the public?
Right, I think there are definitely improvements that could be made. I mean, I think that one easy fix would be same-day audio release of oral arguments. So now the transcripts are released quite quickly after oral arguments, the written transcripts. But audio usually happens at the end of the week, so quite a bit of time has passed. And the news cycle is sort of quick, right? So if an argument happens on Monday and it's not until Friday that the audio is available, there isn't as much press around a case. And I have found the court will occasionally grant requests, and particularly sort of high interest cases, like for example the arguments over the Affordable Care Act's constitutionality. The court did allow for same-day release of those oral arguments. So it was a couple of hours after the arguments happened, and that was actually 3 separate days of oral arguments. So I think each of the days arguments was released within hours, and that meant that news outlets could actually include clips of the audio, which I think just made the whole case far more accessible to sort of the public than it would otherwise have been if it's just reporters sort of providing summaries. So to hear Justice Scalia's questions, to hear the kinds of answers that the lawyers gave, I think served an important sort of public educational benefit. I think it did. I think that cameras in the courtroom could be useful too. I mean, that's a longstanding debate, obviously. It doesn't seem as though the current court is very likely.
Why don't they like it?
They've made a number of suggestions. One is that it would change the conduct of the lawyers before them, so that the lawyers would be performing more for the cameras than for the justices, so that there's a purity to the process now that might be compromised by cameras.
Do they say it might change their performance?
They say it might. Some of them have suggested that it might, that the justices themselves might also be influenced by the presence of the cameras. And then there's a general position that I've heard, which is the sort of, if it's not broken, don't fix it. Our current system works quite well. And we may not know exactly what problems might ensue from introducing cameras, but we know that we know what we don't know for sure, that it might not sort of corrupt the process or compromise the process. And so out of caution, maybe don't sort of allow such a fundamental change. And there have been some experiments in state courts and in some of the lower federal courts with some limited broadcasting of proceedings in courts. And it doesn't seem as though any major problems have materialized. So to the extent that that kind of empirical evidence is persuasive, maybe in a few years, once that's sort of become more common, the justices might be willing to reconsider it. But it's a sort of perennial issue.
Do you think this court is any different from past courts?
You know, it's hard to say for sure. I think that the general sense is that they're quicker to sort of invalidate acts of Congress, right, legislation, and there's some evidence bearing that out, that there's kind of a lower bar that they're employing in terms of when they'll invalidate an act of Congress. But when, every court has struck down what they believe to be unconstitutional statutes, and they should. So, I think in the middle of it right now, it's a little bit hard to say. It does feel like there's a higher degree of sort of what some would call judicial activism on this court.
It's so interesting because, we've always heard about judicial activism from the Republicans, not necessarily from the Democrats, and now we hear it from the Democrats. But the court seems to me to reflect the same dynamic that's happening in Congress, is that it's really kind of polarized as far as the opinions go. And I wonder if when it strikes down a congressional act, if we had a more unified Congress, the Congress wouldn't find a way then to legislate as a remedy to what the court has done.
Yeah, there was a great piece, I think, last year in the Times, Adam Liptak wrote about sort of the increasing dysfunction in Congress actually really empowering the Supreme Court. So, right, when the Supreme Court strikes down a statute, historically, Congress just passes a new statute that sort of addresses whatever flaw the court has identified. And the incidence of that has radically dropped. So there's been some good scholarship on this. It's something like, I believe it's something like once every other year rather, Congress will override, essentially by passing a new statute, a decision of the Supreme Court where historically it's been much, much more frequent, 3 or 4 times a year. There was an active dialogue between a functional Congress that sort of could see something that it objected to and sort of respond to it, and this Congress. So I think that the evidence really bears out that observation that it's having this effect of really empowering the court. And sort of to your other point about politicization, there's an interesting sort of observation about this court. For the first time, you have what are sort of viewed as the kind of liberal and the conservative blocs on the court, and then, of course, Justice Kennedy as the swing vote. And you now have, for the first time, with Justices Kagan and Sotomayor on the court, perfect alignment of sort of party of appointing president and sort of perceived ideology of the justices. So when you had Justice Stevens and Justice Souter on the court, they both voted with what was sort of known as a liberal bloc, but they had both been appointed by Republican presidents. Now you have all the liberal justices are Democratic appointees, and all the conservative justices are Republican appointees.
And are the Court of Appeal, are they justices or judges?
Judges on the Court of Appeals.
Judges. Do the judges tend to appoint now the same party that they are?
Well,
So do the justices, each justice has 4 clerks, right?
Right.
So does each justice tend to select the same political
I think in terms of how
philosophy?
much they sort of screen their clerks ideologically, I think it depends on the justice. I think that there certainly is nothing explicit that I saw in the interview process or anything that selects for that. And in the Court of Appeals, I think it's probably even less the case that there's explicit selection for ideology. I think it's maybe there's a natural affinity that sort of plays out, and maybe it does happen more sort of deliberately. And the clerks actually a lot of the time will screen applications before they go to the justices, so the clerks may sort of be doing more explicit sort of ideological screening before they even pass names to their justices. So there may be some of that.
In the Affordable Care Act, when Justice Roberts voted with the liberal to uphold it, but he didn't oppose the Interstate Commerce Clause. What does that mean? What are the ramifications of that?
I think it's a little bit to be seen. Right, so the Chief Justice found—
I get a feeling it's a little tricky.
And a lot of people thought that, right? So it's really, the question is whether Congress possessed the power to pass the Affordable Care Act. So ordinarily, judicial restraint would dictate that if you find an enumerated congressional power, and here the Chief Justice said, well, Congress's power to tax and spend justifies the passage of this legislation, you actually don't need to say anything else about what other powers wouldn't justify the sort of a passage of a particular statute. So here you had the Chief Justice saying this was justified, this was constitutional, but Congress couldn't have, as an exercise of its Commerce Clause power, done the same thing. So it's unclear, because that wasn't necessary to resolve the case. It's arguably just what's called dicta, right? Sort of something in a judicial opinion that actually doesn't have any binding effect. Sort of everything he said about the Commerce Clause arguably doesn't really mean much. That said, it's a statement by 5 justices of the court about the limits, and sort of maybe unprecedented limits, on what Congress can do under its power to regulate commerce. So I think it was largely read as a sort of stealth move, right, to potentially curtail the Commerce Clause power, but to do it in a case in which that curtailment didn't have any immediate effect, but that could sort of down the road kind of lay the foundation.
So you have to look for another.
It'll sort of.
You're going to have to look for another case.
We won't know until the next case.
Cert,
yeah, that's right.
That's interesting. So the docket this year is quite strenuous, also.
Yeah,
I mean, last year had the DOMA and the affordable health care. So this year we've got what? We've got the affirmative action, which is already argued, campaign finance.
Yeah. So right. So McCutcheon, which was argued in the first week of the term, is the next big campaign finance case, right? So that's a challenge to the aggregate limits, right? So obviously people are pretty familiar with Citizens United, which had just to do with kind of independent spending on elections. And what's at issue in McCutcheon is what are called the aggregate limits, right? So there are limits to how much you can give to a particular candidate, and there are limits to what you can give to a party or to a PAC. But separately from all of that, there's a limit to how much you can give overall to all candidates and parties and PACs together. And right now it's about $123,000 in every 2-year cycle. So it's already a lot of money, but there are still a lot of very wealthy donors who say, we'd like to max out to give, about $5,000, a little bit more, in each cycle to say all of the congressional candidates, and if you maxed out to all the congressional candidates and to all the parties and all, you'd be in several millions of dollars, right? Far, far above 123,000. Now the court has historically been pretty permissive when it has come to reviewing limits on contributions, and this is a kind of contribution limit. So if the court is going to sort of adhere to its prior cases on campaign finance, it would be very hard to see it striking down this aggregate limit. But the sort of flavor of the oral arguments was such that I think that it looks like these, at least in part, might be invalidated, and that would be another sort of significant blow to kind of the ability of Congress to regulate money in elections.
What's interesting is also McCutcheon has brought the case in New York State. Does that happen all the time too? Well, he's got it before the court.
Well,
how many other states has he brought it?
Let's see. So he's in Alabama. You're saying that the Second Circuit decision, right?
Right.
So McCutcheon itself didn't arise in New York. Right. Yeah. So now that's right. So there's McCutcheon himself as a plaintiff. You're exactly right. In the case that has just resulted in the invalidation of the New York sort of version of the law that was at issue in Citizens United. I think that sort of a multi-prong attack on all various statutes like this is pretty common. So it may be that at issue. So that's sort of the independent spending kind of regulation question. And I think it's true that and I don't know if there are challenges pending, but if the aggregate limits in this case are struck down, the federal ones, then there will be very similar challenges to a lot of states. Yeah.
And it'll be a disaster.
It'll mean a lot, well, it'll just mean a lot more very, very wealthy individuals will be able to sort of more directly probably contribute to, and thus, you might argue, control the kind of
There was an
political
example
process.
today in the paper, because we're talking about now the FDA approval of certain drugs. And you saw that the chair of the House committee who opposed the FDA regulation got something like $300,000 from drug companies. So you constantly see it, and it's so frustrating when the court doesn't see it the same way that we do.
Right, and you know, Justice Kennedy says a couple things in the Citizens United majority opinion that just don't seem to sort of they don't seem consistent with sort of our intuitions, right? So he says, yes, it's true that you can buy sort of influence and access if you sort of spend a lot independently. But that's not corruption exactly. And it's just not clear why those wouldn't sort of, to allow sort of certain sector of the population to have sort of outsized influence and access, does seem to sort of corrupt the process from the perspective of people who don't have sort of that ability to influence kind of policy. But the court doesn't seem to sort of appreciate anything but this very narrow conception of corruption, where if you're not actually paying for a vote, and I'm sure the conduct that you're describing happens in more indirect ways than that, then it's sort of definitionally not corruption.
Do you bring this appreciation of the law, I can't quite phrase it, in such a balanced way? Does it cover underneath a more balanced, a more unbalanced opinion of some things?
I wonder. I mean, I do have strong views, but maybe clerking, particularly when talking about the court. I mean, it is funny. I think that there's a degree to which when you clerk there, you sort of do develop a degree of allegiance to the institution. I mean, I think that without question, there are reforms that would improve dramatically sort of the public's perception of the court and sort of the court's
decisions
standing.
most likely you would like to see different.
Absolutely, of course. And you know, cases that were decided, I thought, wrongly when I was clerking there. I mean, there's no question about that. But you do emerge with a degree of just general respect for the institution and players in it that maybe you're picking up on.
Well, Kate Shaw, I think that anybody who's in your classes is very lucky. I wish I was a law student. Thank you very much.
I enjoyed it. Thanks so much.
Thank you. Is there any people you'd like to hear and topics you'd like us to explore? Please let me know. You can write to me at CUNY TV, 365 Fifth Avenue, New York, New York, 10016, or you can go to the website at cuny.tv and click on Contact Us. I look forward to hearing from you.